Hello everyone, I'm Aratrika Bhomik and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court and then cover High Courts and other subordinate courts. If you like our content, please do not forget to like and subscribe to our YouTube channel. The Supreme Court today posed several pertinent questions to the state of Gujarat regarding the case against social activist Teesta Setalvad, who was under custody since June 25th over alleged fabrication of documents to file cases in relation to the 2002 Gujarat riots. A bench led by Chief Justice of India, UU Lalit, at one point during the hearing even indicated that the court will grant interim bail to Teesta Setalvad but ultimately adjourn the hearing to tomorrow at 2 p.m. pursuant to a request made by the Solicitor General of India. The bench comprising CJI UU Lalit, Justice S. Ravinder Bhatt and Justice Sudhashnu Dhulia was hearing Teesta's appeal challenging the Gujarat High Court's refusal to grant her interim bail. During the hearing, the bench also remarked today that 4 or 5 features of the case bothers them. For a detailed coverage of today's hearing, you can refer to our earlier video, the link to which has been given in the description box below. The Supreme Court today, while hearing a PIL seeking to declare the Hindus, Buddhists, Jains and Sikhs have similar rights to administer their religious places without state interference like Muslims, Parsis and Christians, orally remarked that the petition was not supported by any material. A bench comprising CJI Lalit and Justice Ravinder Bhatt was hearing a petition filed by former BJP Delhi spokesperson Ashwini Upadhyay. Apart from the above declaration, the petition also sought to strike down laws made by all states to regulate temple endowments as violative of Articles 14, 15 and 26 of the Constitution of India. In a plea seeking directions to stop attacks against Christian priests and Christian institutions across the country, the Supreme Court today directed the Union Ministry of Home Affairs to obtain verification reports from 8 states, namely Bihar, Haryana, Chhattisgarh, Jharkhand, Orissa, Karnataka, Madhya Pradesh and Uttar Pradesh on the steps taken by the respective law enforcement agencies with respect to the violence alleged in the petition. The Apex Court was of the view that the collated reports would help them in forming an opinion on states' compliance with the directions issued in the judgment of Tehseen Poonawalla v. Union of India. A bench comprising Justices D.Y. Chandrachud and Hema Kohli stated that the chief secretaries of each of the 8 states are to provide information on the following aspects pertaining to their verification reports. Number 1, registration of FIRs. Number 2, status of investigation. Number 3, arrests made. And number 4, the charge sheets filed. In a recent judgment, the Kerala High Court has expressed concerns that the consumerist culture of use and throw has affected matrimonial relationships. The High Court has lamented about how the younger generation is seeing the institution of marriage as evil and how live-in relationships are on the rise because the younger generation believes that marriage has to be avoided in order to enjoy a free life. Emphasizing further upon the younger generation's purported views on marriage, a bench comprising Justice A. Muhammad Mustaq and Justice Sophie Thomas has observed, and I quote, "Nowadays, the younger generation think that marriage is an evil that could be avoided to enjoy free life without any liabilities or obligations. They would expand the word wife as worry invited forever, substituting the old concept of wise investment forever." We have made a detailed video on this ruling, the link to which has also been given in the description box below. The central government has opposed the petition filed by US-based microblogging platform Twitter, questioning several takedown orders issued by the center to pull down content including accounts regarding farmers' protest, alleged mismanagement of COVID-19, among others. In its statement of objections filed before the Karnataka High Court, the centre has said that it is not for an intermediary platform like Twitter to define what free speech is and what content will cause national security or public order issues. The government has further alleged that Twitter is a habitual non-compliant platform and that the instant petition is nothing but an attempt to challenge the compliance mandated under law. The Kerala High Court today dismissed the plea moved by the Principal District and Sessions Judge Kozhikode, challenging his transfer order to the post of Presiding Officer, Labour Court of Kollam. The transfer was made after the judge made the very controversial, sexually provocative dress remark in the order granting bail to Civic Chandran in a sexual harassment case. The bench of Justice Anu Sivaraman observed that the petitioner, who is a member of the higher judicial service, cannot be said to be prejudiced in any manner for his posting as the presiding officer of Labour Court, which is a post born from the cadre of a district judge. Stressing that in a democracy under our constitution, people have the right to protest against government policies, provided the protest does not lead to the commission of an offence by the protesters, the Allahabad High Court today modified the sentence awarded to ex-MP Anu Tandon and others in connection with the Rail Rako protest case. The bench of Justice Dinesh Kumar Singh observed that except for detaining the train for 15 minutes, there was no damage to private or public property by the protesters, and by and large it was a peaceful and symbolic protest. With this, the court found that the imprisonment of 2 years awarded by the concerned sessions judge to Tandon was unwarranted, and therefore the impugned judgment and order was modified to the extent that the appellants were sentenced with a fine only. Utova Savukushankar today appeared before the Madras High Court in the contempt case against him and said that he stood by his statement and that the entire judiciary is riddled with corruption. The case has been adjourned to September 8th after Shankar sought time to file a counter affidavit. The court had initiated suo motu contempt proceedings against Shankar after he made these particular remarks in a YouTube interview with Red Pix channel. The Kerala High Court today allowed the petition for police protection to the employees and workmen of MS Adani Vizhinjam Port Private Limited and its contracting company, and also for free ingress and egress to the construction site. Justice Anu Sivaraman, while allowing the petition, observed that there is no doubt that the right to protest or agitate cannot mean that there is any right to obstruct or cause damage to the project. The Bombay High Court has granted interim protection to slum dwellers against demolition orders issued by the Slum Rehabilitation Authority, citing the ongoing Ganesh Chaturthi celebrations in Mumbai. Justice Sandeep K. Shinde granted relief to the petitioners who were challenging the legality of such orders and notices for demolition of their huts. Thank you. Keep watching Courts Today on LiveLaw for more such updates. If you like our content, please do support us and like and subscribe to our YouTube channel. See you tomorrow.